Okay, so let's compare what the court held in CA Inc. with what the court did in the Kistefos case. So again, we're looking at the tension between the power of the board to run the business operations of the company and the power of shareholders to govern, to select the directors, board of directors, right? Shareholder governance. So, Connie, why don't you tell me briefly about the facts of the Kistefos case?
Sure. Kistefos is a shareholder in Trico Marine Services, and they issued a proposal with sort of 4 proposals dealing with the number of the directors and the board. They wanted to add
But first, are they a majority shareholder in the company?
No, 22.2%
right,
shareholder.
so they're a minority shareholder in the company.
Yes.
And they want to, as a minority shareholder, propose amendments to the bylaws.
Yes.
Okay.
And the bylaws concern the number of directors and composition of the board.
Right, okay.
So they would like
are
to...
Are those proper subject matters for the bylaws?
They are.
Yes, that's correct. Okay. So?
So they wanted to increase the number of directors to make 6 of them United States citizens. They wanted to increase the number from 7 to 9, have a proposal to remove a current director from the board, and wanted to nominate 2 new people as directors if the proposals were all adopted.
Right, so those are pretty straightforward procedural rules with respect to the board of directors. The shareholders have the power to set the number of directors, to elect the directors, right? The U.S. citizens, I don't know, but that's within the scope of the shareholders' power, whether it's permissible. But then there was this Proposal 8. So tell me about Proposal 8.
Well, Proposal 8 dealt with a corporate policy that Trico already had. Proposal 8 said that if any director failed to receive the number of votes required to re-elect them, they were automatically off of the board and a vacancy in the board of directors would exist.
Right, and what did the board of Trico say in response to that proposal?
The board of Trico said that that violated the director's duties under 141B and K.
Right. So basically, the directors were saying that it's their obligation to submit these to the shareholders, right? And it would violate their obligations if they submitted something to the shareholders that would not be enforceable, right? Either under the Articles or under Delaware law. So they rejected the proposed bylaw. So what did Kistefos do then?
Well, so Kistefos is filing a motion to expedite. So he wants to make sure that this is discussed at the shareholder proposal that's coming up very soon.
Right.
And so he wants the court to make a decision quickly on this matter so that he can get Proposal 8 onto the ballot in front of the shareholders.
Right, so what he's worried about is that the board of directors is just trying to run out the clock, right? So the shareholder meeting is coming. If it doesn't get approved by the time of the shareholder meeting, it'll be too late. He'll have to wait at least a year until the next shareholder meeting to bring this up again. So he's asking the court to expedite the proceedings to rule that this has to be included. This proposed bylaw has to be proposed to the shareholders at the shareholder meeting, right? So what does the court say about that?
So the court essentially takes a kind of a wait and see approach to this. They kind of look at both sides of it and decide that they can allow the they're going to allow it to go to vote at the shareholder meeting. And Trico Marine Services they call it preserve their legal position. So essentially they're recording the fact that the corporation is concerned the Proposal 8 might violate their duties under 141 and their certificate of incorporation, but they think that it should go to vote at the shareholder meeting, and then only at that point actually will the issue be ripe of whether it's a violation. Right,
so it's an interesting contrast here, right? They're saying on the one hand, this is potentially an inappropriate bylaw, right? And if it clearly were an inappropriate bylaw, it would not be permissible to go to the shareholders. And on the other hand, they're saying the fact that it's going to the shareholders preserves your claim that it's an inappropriate subject matter for the bylaws, right? Online student, does the court hold that if the shareholders approve this bylaw, that by itself will be sufficient to cleanse any problem with the bylaw and make it a formal part of the bylaws?